to Kelly Dry's Adler Access podcast, and this is Simone Roach. Recently, South Carolina Attorney General Alan Wilson proclaimed, if Congress won't protect kids from big tech, states will. State AGs from 27 states, led by the Utah Attorney General's office, submitted an amicus brief in the Computer and Communications Industry Association et al. Versus James Uffmeyer case on appeal before the 11th Circuit. In that case, the plaintiff challenges the legality of Florida's content moderation law, HB 3, otherwise known as Florida Statute Section 501-1736, which was enacted to prohibit certain social media platforms with addictive features from providing accounts to children 13 and younger, and from providing accounts to children ages 14 to 15 without parental consent. The lower court blocked Florida from enforcing the law, finding that the law implicates the First Amendment, yet fails the intermediate scrutiny test because it burdens protected speech of under 16-year-olds despite the availability of substantially less burdensome alternatives. And in their brief, the states argue that Section 501-1736 is content neutral and readily passes intermediate scrutiny and therefore should be enforced. The states cite their interest in the case by describing adverse mental health outcomes among teenagers and allegedly addictive elements of social media, noting that amici states have compelling interest in protecting children and youth from the harmful effects of excessive social media use. Days later, 44 AGs wrote a NAAG letter to 12 AI companies to inform the companies of the AG's resolve to use every facet of their authority to protect children from exploitation by predatory artificial intelligence products. And while the letter gives credit to the innovative technology of AI, it encourages the AI companies to succeed without sacrificing the well-being of our kids in the process. In the letter, the AGs explain that recently revealed documents from one company demonstrate an awareness of exposure of children to highly inappropriate sexualized content, including chat conversations with AI. But they also recognized that these risks are not isolated to one company. The AGs further state that children are consumers too, and that conduct is not excusable just because it is done by a machine versus a human. They explain that this is not the first time they have needed to address new and powerful technology in big tech, alluding to their past big tech enforcement actions, and assert that children cannot become victims again. The letter encourages the companies to use their opportunities to exercise judgment wisely, saying what it comes down to is, don't hurt kids. It further promises AGs will hold the companies accountable and wishes them all success in the race for AI dominance. And this is not the first time AGs have been at the forefront on supporting or enforcing social media laws and policing AI companies. And it definitely won't be the last. In fact, just this week, the 47 AGs announced another NAAG letter aimed at addressing deepfake pornography. Stay tuned as we continue our coverage. And if you'd like more information on what you've heard on this topic, please contact either Paul Singer, Abigail Stempson, Beth Chun, or Andrea deLorimier, and you can find their contact details in the show notes. And also, please see our Advertising and Privacy Law Resource Center available at kellydry.com.